I'm an immigration lawyer in the Kent Law Clinic, and my role, as with Philippa and Viv's roles, we take cases for local clients, as well as teaching students about our specific subjects, in my case, immigration, nationality and asylum law. And I've also recently published a book which identifies what I think is wrong with the immigration control system in this country, and details about the book are at the end of the slideshow. Today I want to talk about a very recent piece of immigration law, the Nationality and Borders Act, and I want to use that to talk about recent issues in immigration law, and to highlight the differences between law and politics, and between law and our ideas about the society we live in. And what I hope I'm going to do is show you not just the differences between law and politics, but also the similarities, and how we have to be careful that we know what it is we're doing when we're acting as lawyers. Just to start then, this is probably somewhere like Heathrow Airport, and many of you who follow the news might notice that whenever there's an immigration or a refugee issue in the media, the Home Office always says something like, Britain welcomes refugees, or Britain welcomes genuine refugees. And I'm now asking you, all of you, to think to yourselves, does Britain actually welcome refugees? What do we think about that? Do we think Britain should welcome refugees? Do we think Britain should just welcome our share of refugees? And if so, how might that be worked out? And should Britain welcome refugees only if they ask permission to come here first? And I'd like each of you to think about your answers, and then later on, think about them again and think, have I changed my mind about any of these things? Or have I become less or more sure about what I think about these issues? Just some statistics to start off with. We've seen how Russia has invaded Ukraine, and up to the end of May, around 6 million Ukrainians had fled their country. And we can see from this slide, which you don't need to look at in detail, that over 3.5 million of them have crossed the border into Poland. And you can see how many have gone to other neighbouring countries. But what I want to draw your attention to is that the UK alone in the whole of Europe, and I don't just mean the European Union, I mean all European countries, Britain is imposing visa controls. And so only about 60,000 Ukrainians have so far reached the UK. Now we can look at what's happened in Afghanistan. People may remember seeing last August planes hoovering up people from Kabul airport trying to rescue them as the American troops left and the Taliban took over. And once more we can see on the left in this chart, Pakistan, the neighbour of Afghanistan. There's 1.5 million people approximately from Afghanistan have sought refuge in Pakistan. And if you follow the slide with great difficulty, because it's in very small writing, you can see at the bottom, it says the UK has proudly accommodated 12,600 Afghans in 2020. Okay. And lastly, on the figures, people may remember in Syria, there's been a harsh civil war for about the last 10 years. And once more, we can see that on the left-hand side, over 3.5 million Syrian people have sought refuge in Turkey. And we can see the other main countries, Lebanon, Jordan, and the first European country is Germany. And as I said with the last slide, if you let your eyes go along the bottom to the right, you will see that the United Kingdom of Great Britain and Northern Ireland has proudly accommodated 11,412 Syrian people. And so just pausing there, does anyone want to say in the chat whether they've changed their mind about whether Britain welcomes refugees? And while you're thinking about that, we'll just move on a little. So I don't know if anyone's...
yeah, well, I mean, I can give my own view, Sheona. I mean, having worked with you for like 7, nearly 8 years now, I was really surprised when I looked at those statistics. That's not what I expected at all in terms of numbers compared to other countries.
Well, if people look, when we get to the end of the presentation, you'll see I've given some links. And one of them is to the UNHCR, the UN High Commissioner on Refugees. And they publish statistics every year. How many refugees are there in the world and where have they all gone? And you can see that pretty much half of them have gone to the country that's right next to the one in which the war or the civil war has broken out. So yeah, that's how it is. And of course, Britain, being at the top left-hand corner of Europe with an extra sea all the way around it, it's quite difficult for people to get to the UK.
So, Sheona, one of our students, Evie, she's just replied and she said that so far her answer hasn't changed, that she doesn't think the UK are overly accommodating towards refugees.
Well, she has my support with that point of view. Okay, that's shared. Yeah. Moving on then to make some general remarks, which are that UK immigration control is actually very strict. And I think this might be something else that comes as a surprise to a lot of people, because the media the impression people get from the media is that immigration is enormous and is out of control. The truth is that since a particular Act of Parliament in 1971, everybody, apart from British citizens and for 40 years EU nationals, are subject to controls. And what that means is you can't come here unless you apply for permission first. There are a couple of small places where people don't have to apply for visas in advance, but in terms of numbers, this is completely trivial. And obviously, since Britain has left the EU, EU nationals now have to apply for visas before travelling here, unless they're just coming on holiday. The next thing I can say, relying on my over 40 years of immigration law practice, is that the controls are poorly administered and people wait months and years for decisions. And currently, over half of those who are refused permission to come here eventually win their appeals. So you could say it's almost like tossing a coin. You could apply for a visa and the Home Office could toss a coin and they might achieve, you know, the same level of accuracy, legal accuracy in making their decisions. And sorry, yes.
Questions just come to me naturally. Out of interest, Sheona, what is the longest you think you've waited for a decision for a client?
The longest I've waited is probably, well, I think it's, I would say in normal circumstances, by which I mean, say, in the last 10 years, probably 3 years, I would say. But there was a period during the 2000s when famously the Home Office revealed that they had 500,000 files on people which hadn't been dealt with for several years. And people routinely had clients who'd waited over 10 years for a decision. And I don't think people are aware of this. I think people think that public administration is declining now, and people are waiting for all sorts of decisions. you know, whether it's NHS treatment or renewing their passport or whatever. But that's relatively recent in other areas of law and administration. But immigration control has been like that for 40 or 50 years.
So, yeah. Sheona, when people are waiting for decisions, are they likely to be waiting outside the UK for a decision on a visa or inside the UK, or is it a mixture?
It's a mixture. And people who are here with permission, who apply to extend their permission to stay, at least those people carry on having the same rights that they had before, however long they wait. Although I am finding that clients have difficulty proving that they've got the right to work, even though they have. But people who are outside, they are having to do this waiting in very difficult circumstances. I'm waiting for an answer to an appeal where I've got 2 teenage clients living in a foreign country as refugees. And they've been waiting for about 1.5 years for permission to come and join their grown-up sister. And
Sheona,
just, yeah.
Some really interesting questions are starting to come through in the chat. So I want to thank Mima for her question and Francesca. I don't know if you want to answer these now, or they may be ones that we want to allow you to tell us a little bit more before we talk about. But Mima's asking about what implications the revocation of the Human Rights Act may have in the future. So that's something that we may want to leave for a little while and come back to.
Could I say on that?
Yes.
Yes, we've just read the bill that was published yesterday. My colleague Rick and I have just had a discussion about it. And some of the terms of that act are devastating. I'd like to leave that a little bit towards the end because it brings in an area of immigration law which wasn't going to be the subject of this discussion, but I'm happy to talk about it nearer the end. So if you could remind me.
Yes, absolutely. Another really interesting question, which just shows how well informed you guys all are out there and that you're reading. Francesca's asked about government proposals to reduce the number of civil servants and how that is going to impact, you know, the reduction of administration. How might that impact upon these controls, do you think?
When that was announced, and I think it was Jacob Rees-Mogg that announced that, I nearly wrote straight away to newspapers and so on, just saying you could just send those 90,000 people who you think are surplus to requirements to the Home Office and get them to deal with, firstly, the Ukrainians who are fleeing Ukraine, and secondly, all our other clients who are waiting for their regular bog standard family visa extensions. And any other area of law where people have been facing unconscionable waiting times and backlogs. Obviously, that's a really foolish and stupid policy. No qualms about saying that.
So there are more questions in the chat coming in.
Okay. Shall I move on a little? Shall I move on a little? Now, just on the issues of refugees, we get people saying, well, why should any of these people come here? And we also get people, I'd say, at the other end of the spectrum saying, well, isn't it awful? Surely we must be able to do something to help these people. I'm reminding us that this is from Kent Law School, this presentation, and I'm a lawyer. And so I'm going to read out to you what the judge in the Court of Appeal said last week in the case about sending people to Rwanda. He said, courts cannot enter the morals, ethics or merits of the government's policy. And he went on and said, and in fact, the lawfulness of the scheme is not before this court today. All we're talking about today, this is a judge in the Court of Appeal. He said, did the judge in the High Court exercise his discretion properly or not? And so really that's just something needing to be said, before discussing what we as lawyers think about how legal problems have to be approached. We have to start with the relevant law, we have to know it and understand it. And then, of course, we have to think about our client's own individual facts, and we have to apply the law to those facts. And if we catch each other in the clinic or in previous places that I've worked, if anybody says, isn't it awful? Or if anyone says, but surely the government can't mean this. And we say, yes, they did. Or if they didn't mean it, they are indifferent or careless about that consequence of some particular law. Okay, and I wanted to make a little bit of personal history here, and I would say that being a lawyer is a bit like rock climbing. And if you think about what rock climbing is like, you need to be careful and precise, and you need to back up your client's claims with solid evidence and arguments. But obviously, just like rock climbing, advancing your client's arguments, especially in the immigration and asylum context, involves taking risks. So before we move on to any more from the chat, here's a couple of questions I'd like to ask the participants here. Does anyone think people have a right to claim asylum? And in particular, does anyone think people have a right to enter another country to claim asylum?
Okay, you might need to give people a couple of minutes to think about that and say something.
For those of you, if you just put your answers in the chat, a simple yes, if that's what you want to kind of say or expand upon that, please just use the chat and we'll read them out, because unfortunately we can't open it up so you can actually speak.
And bear in mind, everybody, I can't even see you. I'm only having to be convinced that there are people, that you are there.
Okay, shall I tell you what we've got so far?
Yes.
So we have, who is this from? So from Imogen, we have that people should have a right, but I don't think they do. Okay. And then we have another contribution from Shivatsa, who says, if that right isn't abused, then yes, people have the right. Okay. That's what we've got so far.
All right. So here's what the Refugee Convention says, who is a refugee. So I'll just read the beginning. Owing to a well-founded fear of being persecuted for these particular reasons: race, religion, nationality, membership of a particular social group, or political opinion, who's outside their own country and is unwilling or unable, and then it says here, to avail themselves of the protection of that country. And what that means in ordinary language is that they are unwilling to go back home. So we can see here that the Refugee Convention doesn't tell anybody that they've got the right to do anything. What that's addressed to is what a receiving country has to think about that person. So I'm going to say, well, I'm Britain and you've just landed on the beach in Folkestone, and I've got to apply these tests to you. I've got to ask you questions so that I can find out whether any of this applies to you. But this is a lot of writing, but if we think about what it's saying overall, the only duty that the British government has got towards anybody is not to send them back to anywhere where they're going to face persecution or any of these other problems. That's the only duty. And so now maybe it will be more clear why the British government tries so hard to stop people landing, because it doesn't have any duties to anybody until they have got here.
So Sheona,
yes.
This might tie in with contribution, a message from Nima, who says the law is clear that you cannot claim asylum if you're coming from a safe country. So legally, asylum seekers arriving from France do not have a right to apply for asylum.
Actually, there's nothing in the Refugee Convention, nothing whatever, which tells people where they have to seek refuge. And in fact, in response to this new Nationality and Borders Act, the UNHCR has said that if people were restricted to claiming asylum in the first safe country they reached, that would completely wreck the world system of looking after refugees, because plenty of refugees, millions of refugees, move beyond the first country they get to and move around the world. Generally, it's quite true, they generally move to neighbouring countries or places on the same continent as their own country. But there's nothing in international law which says that that's what refugees have got to do. The business about the first safe country is something that Britain encouraged the European Union to adopt in the 80s when asylum seekers first started coming to Europe. So it's, you could say it's a piece of domestic law. It's not part of the International Convention at all. But what the Refugee Convention didn't do was it didn't give anyone a right to enter another country in order to claim asylum or in fact to do anything. And so people are caught in a kind of limbo when they leave their own country, but they're not allowed to be anywhere else. So it's a very, very difficult legal problem. Is there anything else in the chat?
There is, Sheona, but I think we're going to let you carry on speaking for a little while. There's some great questions, but I think we may save a few of them up for the end. Okay,
all right. Now, so here I just put some political statements on here. You know, why, if so few people actually get to the UK, you know, why is the government always so frantic about controlling what actually happens at the border? And I'd say it's quite interesting. People talk about the dangerous crossing of the channel, and I'm sure it is, and I wouldn't get in a boat and cross the channel, but many more people died, you know, being shut in refrigerated lorries or, you know, falling out from underneath trains and things like that than actually have perished crossing the channel. And the fact is that all illegal routes are potentially dangerous. And the dangers come more from the exploitation of the people than from the physical dangers of the type of thing they do. But what I wanted to go on to quickly before we look at an example is just what the new Act says. Anybody arriving illegally can have their claim declared inadmissible, and so that this means the government won't look at it at all and just send them somewhere else. And if they can't be sent somewhere else, they're going to be treated as second-class refugees. And also, arriving illegally is now a specific criminal offence, which would affect any future rights these people might have. And also, very quickly, the Act has lots of fiddly little requirements about how a person has to put their claim for asylum, making rules about how quickly they've got to produce their evidence and things like that. And so now I want to quickly come on and just show you that the Rwanda arguments have already been all the way through the UK courts. We can go back to that, but I wanted to quickly get to the case study. And I think Viv is going to talk to you about this example family.
Okay, I'm just going to read out what you can see on the screen, the facts of the case. It may be easier to absorb if I read it aloud. So Arjen Shevchensky is a Ukrainian footballer who plays in a UK Premier League team. His family are from Mariupol. as soon as the Ukrainian family visa scheme started, he sponsored his cousin Beata and her 3 children, Nadia, age 12, Oleg, age 16, and Sergei, age 20, to come to the UK. Eventually, Beata and her 12-year-old daughter got their visas and now are in the UK. But her 2 sons were not able to travel with her.
Okay, so this scenario, the Ukrainian family visa scheme allows people to sponsor their families. So this is a set of visas which should and could have been granted in about a day, because the people simply had to show documents to show that they were related to Mr. Shevchenko. And then what the government had to do was just check that none of them were criminals or terrorists, and then just stick a visa in their passport. And in fact, some of these visas, they haven't been even expected to get a physical visa. It's just been done electronically. So it should have happened really quickly. Okay.
So, just to clarify that this is you setting a problem question, which is something that we might do as a way of understanding the legal issues, but this is loosely based on your understanding of various problems that have been happening with the Ukraine.
Exactly, and these are the types of cases that, not just if you're studying law at Kent, you might be faced with problem questions, but in the clinic we may also have real clients with these or similar real situations. And so what we might experience in the clinic is that Beata might come here with her 12-year-old daughter and be sitting in the clinic asking me what on earth she can do about her 2 sons. So let's find out what happened to each of the lads. Okay, so Philippa, do you want to go through?
Sure. So unfortunately, her 16-year-old son Oleg freaked out when the bombing happened in Mariupol and ran away with some friends. They hitched and walked across Europe, got a place in a small boat, and arrived in Folkestone last week. So for those of you that don't know, Folkestone is on the Kent coastline and is a likely area where people might arrive in the UK. The Home Office has decided that Oleg isn't 16, they think he's over 18, and he's now been detained at a place called Napier Barracks, which is a real place just outside of Folkestone, where people are detained when they arrive here illegally.
Okay, so the first thing I want to draw everyone's attention to, and I know it's making me slightly smile thinking about it, is that many young people really enjoy the fact that they are thought to be over 18, and obviously going and buying a drink in a pub is the first thing that you think about. Might be an advantage of being thought older than you are. But for asylum seekers, it is catastrophic to be thought to be an adult. So he's effectively been put in an adult detention centre, and he's been treated as an adult, and all sorts of things might befall him. So does anyone looking in the chat, can anyone think what Oleg can do, or what he might be able to do, or what we might be able to help him with to rescue him from this situation? So just bear in mind that Beata and his sister Nadia are somewhere in the south of England, and in her handbag Beata has got Oleg's visa, which he wasn't able to use. And so has anyone got any ideas what we might be able to say about this or do for them?
It's very good. We'll just give it a minute to filter through. I will say that Mima's been asking some cracking questions, which we're going to come back to in a while. She's clearly got a really good understanding of immigration law, so don't worry, Mima, we're not ignoring you on that front.
There was also an earlier question about is there a difference between adults and children, and Sheona, that ties in with what you were saying about why age is so important.
Okay, there's been a controversy which has lasted about 15 years, which is called age assessment. And effectively, in the last 10 years, many young asylum seekers have been arriving in Kent, and because they arrive in Kent, people who are under 18, Kent Social Services has to look after them, has to take them into care. And this is very, very expensive and difficult for the local authority. And it's also a nuisance for the Home Office, because the Home Office just can't deal with them as adults and put them in detention and all the rest of it. So one of the things that's happened in this new act is that the process of deciding how old a person is has been made much more brutal, because the rule before was that the Home Office, unless they were certain that the person was at least 25, if the person said they were under 18, they had to accept this. Now, the Home Office just has to decide whether they think the person is over 18. And if any of you who are still at school and who are in the sixth form, and you think about your colleagues at school, and you think there are some of you who on a night out might look more than 25, and some of you might still look 13 and 14. So there is the most vast variation in how old people look at that age, and there's no scientific way of determining this.
Mima, earlier on, Mima was asking about documentation, and obviously noting the point that a lot of people arrive without legal documentation. You know, if you've fled a country, you don't necessarily stop to pick up 3 years worth of bank statements and, you know, all the ID documents you've got. So this is a huge problem that you encounter in your work in the clinic, isn't it? Yeah.
But what we can say is, here's some people who were in a family and did make a visa application, and Oleg might know that his mum had made a visa application, and so he might start by giving the authorities in the barracks obviously the names and ages of all his family, and mentioning the fact that his mum's cousin lives in the UK and is actually quite well known, and so there may be a possibility of persuading the Home Office or getting some legal advisor to try to contact his family and get access to his documents. So
there've been a couple more contributions in the chat, and one of them is on that subject about appeal. So can the young person appeal and prove his age with documentation?
Yes, there is now, well, with the act that's just come in, it does give a right of appeal to a determination that somebody is over 18. And this act is so new that I don't know how it works, but it's definitely possible that he can challenge that. And so from inside the barracks, he has to get in touch with someone outside who will act on his behalf. I don't necessarily even mean a lawyer. I just mean any old person who's outside who could find a lawyer, look for his family and do something about this. But I would say he could be rescued from this situation. He can definitely be rescued.
Sheona, could you say maybe a little word about what would have to happen next? Because Evie, you know, she immediately picked up on maybe a judge needs to get involved in this, and there needs to be an argument about whether there's a declaration of incompatibility. So her thoughts immediately went to the court. But is that what would happen straight away in this type of situation?
Having looked at those kind of legal actions, and I would say the Rwanda legal action is like one of these, I wouldn't be inclined to deal with it that way. What I would be inclined to do is to see what practical steps could be taken, whether to get in touch with his family or to make representations to the Home Office, that the Home Office knows who he is there's an outstanding application about him. A visa has been issued for him. His family are here in this country. And this is where, you know, I might say to a politician, to a local member of parliament, but surely, you know, you're not going to treat this boy like this when the Home Office already knows everything they need to know and they have accepted his application to come here. But my bigger answer is, if somebody arrives illegally, which he manifestly has done, would it matter? And in what way would it matter that his mother had previously applied for a visa for him? And very briskly, I'd want to say this is the kind of case where any lawyer might be faced with a completely new problem about which we have to make up a legal argument. We'd have to try things. And that's what I meant about the rock climbing and the taking risks. But I wouldn't do, you know, what your questioner suggested, which is to try declarations of incompatibility. I think, you know, that way madness lies. If you want to help an individual client, you stay with that client and you do what you can for that person. And you might put those arguments in the documents if you got faced with going to court. Of course, you put those arguments in, but you start off by saying it is simply unreasonable and irrational to treat this child that way.
Interesting. Right, should we have a look at his brother?
Yes, I was going to say we need to crack on, because that's another rock climbing thing. If you spend too long on a particular part of the climb, it gets dark before you get
For those of you that haven't worked it out, Sheona York is a very keen climber.
Okay.
Formidable.
All right. So which one of you is going to read out these rather more challenging facts about the older brother?
Go on, Viv.
I'll give it a go. So her 20-year-old son, Sergei, was stopped at the Ukrainian border and not allowed to leave Ukraine because all men over 18 have been called up to serve in the military. He feared this as he has mental health problems and has recently transitioned to female. So he crossed the border illegally. He then made his way across Europe, meeting prejudice most of the way, and he also arrived in Folkestone last week. Sergei is now also detained in Napier Barracks. Both brothers have now been served with removal notices stating that they will be sent to Rwanda next week. Can we do anything for Oleg, which we've touched on, and can we do anything for Sergei now that they've been served with removal notices?
I'm going to interject there and say, although I said in my last answer that I wouldn't be going to court, or I wouldn't beginning Oleg's case by going to court, now that he's had those removal notices, obviously we've got a week. And so what we then do is we would prepare an application for judicial review of that decision, putting in all the facts and evidence about him that we just talked about in the last slide. So that would have to be a court action. And again, it would be based on his individual facts and not on more general arguments about sending people to Rwanda. But has anyone got any views about what we might say about Sergei, who's over 20? So he is definitely an adult.
We'll just give it a minute.
Let me click back. I'm going to click back to a previous slide. Oh, no, wait a minute. That's forward, isn't it? Sorry. Sorry.
It's the simple things.
Right. So this might be useful to people thinking about Sergei, who effectively has run away from his country, not wanting to serve in the war because of his own mental health problems and because he's transitioned to female and obviously would feel profoundly uncomfortable and frightened serving in the army and so on. So we look at what the Refugee Convention says, and does anybody think what he might be able to argue? So I'll take you back to the, shall I leave this Shall I leave this here for a minute?
I mean, there have been a couple of contributions about using the media, but maybe we'll look at the law first. Is that what you?
Yeah. Okay. So obviously, for Sergei, just as with Oleg, if he's got removal directions which have got a notice with a date on it, then you have to be looking at a form of legal action which in which a judge would put a stop on that action until the case is properly considered. And so what might we want to say here? What's wrong with declaring his application to be inadmissible in this country and sending him to Rwanda? What does anyone think might happen to Sergei if he's sent to Rwanda?
So
go ahead.
Oh, yep, you, me. Mima has said that he could make a claim based on the gender issues, as we know that LGBTQ issues in Eastern European countries are not the best.
Okay, so that would be effectively you're suggesting that he would have a well-founded asylum claim against Ukraine. And possibly, as I've said here, he met prejudice most of his way across Europe, probably Poland or Lithuania or whatever countries he went through aren't, you're quite right, are not sympathetic and don't protect, you know, people with who've had gender reassignment and so on. And so you could definitely say that, and that might enable us to contest the idea that his claim is inadmissible because he's walked through a few safe countries. He may be able to argue that there isn't a European country which is safe for him. And I would say two reasons. Number one, you know, their own policies on gender issues might not be that supportive. But secondly, is there any European country that doesn't support Ukraine in that war? And they might utterly lack sympathy for somebody who isn't willing to fight in that war for those issues.
Francesca's kind of opened it up as well, because in this example now we're talking about going to Rwanda next, and she's saying obviously that might also be an unsympathetic country.
Yeah, and
there's another point about mental health. So Maleka said, is it possible to argue that his mental health is something which is affecting him, her, motivating their actions, as well as the fear of conscription? So is that something which is a relevant factor?
Yeah, definitely. And people, if anyone's followed the Rwanda discussion, what some of the charities were arguing in the unsuccessful court case is that both the Home Office's procedure in deciding who to send to Rwanda and also Rwanda's own asylum determination procedures are not detailed enough and don't give enough space to people who have experienced torture, who are vulnerable because of their mental health conditions and so on. So that's one of the grounds of challenge that's been explored. And in the very next slide, which I can go to right now, just to let you know that one of the main reasons the High Court and the Court of Appeal dismissed the Rwanda case was the very fact that it was the Home Office has changed its mind. There was something like 130 people supposed to be on that plane, and it got bargained down to about 10 in the end. And then those people, the Home Office, withdrew the removal decisions. And so what the courts were saying was not that the argument about Rwanda was rubbish. They were saying that individuals should put forward their own reasons for it not being an appropriate policy, rather than trying to challenge the policy itself. Okay, so I think that you know, going back to Sergei's individual situation, I think he might stand a good chance of not just not being sent to Rwanda, but his asylum claim not being decided as inadmissible. because he's passed through some safe countries. What his problems are going to be is, you know, I could go back to one of the slides. His problem is going to be getting the evidence together in that quick, short time. And so, I mean, I met a couple of barristers on the Friday night of the High Court case, just completely coincidentally in London at a concert. And they said that in their chambers, which is Garden Court Chambers, they had been working day and night. They had a team of 8 barristers working on those cases, you know, just preparing the individual applications from people who didn't want to be sent to Rwanda. But nobody's been sent yet. Nobody's been sent yet.
Fantastic. Sheona, it's just coming up to 10:02, and I want to leave you some time at the end to deal with some of those more general questions. So just so you know where you are.
Right, thank you. So I just wanted to say very quickly, just to sum up really what I've just said about the types of legal arguments. And these cases show that there's 2 types of argument. You know, whether the law and the rules are unlawful, maybe because they're in breach of the Refugee Convention or the European Convention on Human Rights, and whether the treatment of my client is unlawful. And this conclusion that I'm putting to everybody is born out of literally 40 years of practice, that the first is always headline grabbing and quite thrilling, and sometimes if you win a case like that it's fantastic, but doesn't very often win. Whereas the second kind, you can potentially save your clients. And in the clinic we would say, not just in immigration but in all the areas of law we practice in, the benefits to our clients are wonderful. You know, winning an individual client's case is fantastic. Yeah, and you never forget the legal arguments you've deployed in a case that your client has won. So, yeah.
Can I perhaps just pose there then that human rights question that we had from earlier about what about the revocation of the Human Rights Act? What impact do you think that's likely to have?
Well, we didn't have time this morning, and I'm trying to find, okay, so here it is. The things which stand out are the Home Office's absolute determination to deport foreign criminals. And so if this bill gets passed, a foreign criminal will not be able to advance their Article 8 rights to private life at all. So we gave the example of a leading case called Akinyemi, who's a man who was born in Britain, never lived anywhere else, and he's something like 35 years old, and he'd committed a few criminal offences, and they decided he wouldn't be deported because his 30 years of private life in the UK, being socially and culturally integrated into UK society, is stronger than the public interest in deporting him. He will now not be able to put that argument.
So, Sheona, what's his nationality then?
He's from Nigeria. Well, when I say he's from Nigeria, I cross that out and criticise myself, because obviously that's rubbish, because he's from Lambeth or Peckham or wherever he was born. You know, he's never been anywhere else. And in fact, the Court of Appeal criticised the upper tribunal for deciding he must have some links with Nigeria. Well, why must he? He's never ever lived there. His family are all here. They're all British, blah, blah, blah. And there are plenty of people in that situation who may have committed their crimes a very long time ago and been here 10 years since then. That's the most outstanding, you know, that's the most outstanding thing. But there are more subtle. There are more subtle things, and yeah, it's hard to quickly pick out. It's hard to quickly pick out, but the issue is this, which is that the Human Rights Act is going to be repealed, Britain is staying in the European Convention on Human Rights. But what that means is that if any client wants to say that some public decision is taking away their human rights, how are they going to challenge that? They're going to have to apply in Europe to the European Court on Human Rights. And another thing the bill says is that whatever the European Court of Human Rights decides, the British government doesn't have to pay any attention to it. So you think, well, what good is that? And they certainly don't have to accept injunctions like the ones that were issued for a couple of Rwanda people. Yeah. So, but who knows, really? I mean, the bill's just been published and we don't know how it's going to survive and what's going to happen to it as it goes through Parliament.
Yeah. I mean, there's some really intelligent discussion happening in the chat about, you know, representation of people in these kind of situations and the problems that have been experienced, and legal aid cuts and the possibility of further legal aid cuts, which really great to see students thinking about those, because all three of us would tell you that that is what we spend 99% of our time talking about with students in the clinic who come and work on cases with us. So, you know, spot on with your analysis, students there. Right, Sheona, I think you're at 5.2, so you may want to get to your closing slides.
I do. Okay, very briskly, how are these kind of questions taught at Kent? And before going on to what I've written on here, I would say that any of these issues and any of these types of cases are best dealt with, you know, by students who've got a very good understanding of what you might call traditional legal issues. Tort and contract, and in particular public law, has a very important place in these kind of specialist subjects, such as immigration, refugee law and human rights law. And as you can see, we don't just try and teach what the law says, but we discuss arguments about how those laws either do or don't fit in the UK legal system and in international law. And it must have been obvious to people that also there's the clinical option module, which is now going to run separately in the autumn and then the spring term. And of the students who can get onto the clinical option module, some of you will be placed with either me or my colleague with immigration or citizenship or asylum problems. And what you will find is that any work for any client shows that immigration law is complex, it's hostile, but also just what Philippa was just saying, which is the real difficulties faced by people in getting decent legal advice, because the questions are too hard, the issues are too difficult for the people to do on their own. Okay, all right, lastly then, I was asked to provide 3 things that you need to know about studying immigration and asylum law. Okay, so reading, it might sound obvious, but we have to know what the law says. And in immigration and asylum law, it's complicated. It's very badly written. And I feel I have to apologise every time I ask a student to go and read the immigration rules, because they are pretty much unreadable. But we have to wrestle with this, and we have to understand exactly what the law says. And the next thing is we have to listen. We have to listen to what our clients say. We also have to listen to the arguments on the other side. And we want to listen to all kinds of arguments in different registers, all the way from people in pubs in Dover, all the way through to, I don't know, what's his name, Lord Sumption, who used to be on the Supreme Court. And those kind of people. And lastly, we need to get good at arguing, and we need to be prepared to argue on behalf of our client, but also understand more strategic arguments, and also understand what are the weaknesses in our client's case, And has a Home Office argument ever got any validity? And if it has, we have to be able to recognise it. So reading, listening and arguing. Those are the watchwords to be a good immigration lawyer. Okay, thank you very much.
Fantastic. And Sheona, you can do a plug here because Evie's just asked, what is your book? Because she'd love to read it.
It's the first thing on this slide. And it's on Amazon, an absolutely stupid price. So get your library or somewhere to order it. So
the university library, hopefully.
Well, certainly, yeah. But these other two books that I've put here are, you know, they're kind of more popularly written and not so expensive, but they are full of interesting insights into immigration law in this country. Okay.
The other thing, Sheona, do you know about the next webinar? Because this is one of a series, isn't it?
Here we are.
Great. Okay, so next week, 30th of June, Protests and the Law with Shan and Mohammed.
Fantastic.
Okay. And then after that, Ethics and the Law. If you look at the picture, of the clinic, or rather of the Wiggleder building, you can probably see me at my desk in that top left-hand window.
We'll wave to you.
Yes, okay. All right, are there any last questions that I need to answer?
No, Sheona, you've been wonderful. Thank you so much for doing that. It was really, really interesting.
Thank you, Philippa. Thank you, Viv, for being my friends and comrades during this process.
Well done for all the contributions. Thank you for all the fantastic contributions we had from the participants. It's been great.
Wonderful.
Thank you.
Right, Sheona, you get the last word. Goodbye.
Okay, well, goodbye, everybody, and thank you very much for attending. Hope you found it interesting. Thank you.